There are several equally powerful factors which, when combined, militate against ordering a new trial. In summary, these factors are the insufficient and inadequate account by the prosecution for the availability of its witnesses and trial exhibits. Witnesses and trial exhibits relied upon by the appellants, which tended to support their defense at their first trial, are now unavailable or cannot be accounted for. 3. The appellant's trial in the Supreme Court was complex, lasting 64 days, and utilized a significant share of the court and the appellant's resources. The time, financial costs, expense, and impact on the court's resources, as well as other cases in the queue awaiting trial, we find that this is significant and it militates against a new trial. The psychological, financial, and medical effect that a new trial would likely have on the appellants who have already spent 13 years in custody, which is demonstrated by medical and other affidavit evidence. The lapse of time between the commission of the alleged offense and the likely time in which a new trial would take place, which would, in our estimation, be at least 15 years, we find that to be inordinate. The unjustifiable interference with the appellant's constitutional rights to a fair hearing within a reasonable time under Section 16 of the Constitution of Jamaica, and the potential for that breach or interference, we should say, continuing if a new trial is ordered. We look at the potential prejudice to at least 2 of the appellants who, if convicted after a new trial, would be required to serve a longer term of imprisonment before eligibility for parole than that which was originally imposed upon them after their first trial due to the operation of the statutory mandatory minimum for the offense of murder. Having weighed everything in the balance, that the countervailing the weight is against a new trial. Having regard to all the considerations the court has taken into account, we conclude that the interests of justice do not require a new trial to be ordered for the appellants, and we therefore make the following order. Judgments and verdicts of acquittal are entered in relation to the appellants.